All right, joining us via Zoom to help us make sense of these issues is lawyer and advocate for good governance, justice and equity, Liborous Oshoma. Liborous, good morning. Thank you for joining us at TVC Breakfast.
Yeah, good morning.
Now, the Supreme Court had made a pronouncement that these payments were unconstitutional, yet we still see the Attorney General of the Federation and some consultants making a case for these monies. Help us make sense of this.
Yeah, thank you. But first and foremost, before I go into that, I would say that if you observe recently, in every allegation of sleaze or compromise against any agency of government where governors are involved, Governor Yari's name is mentioned as Chairman Governors Forum. So there's need for detailed and further investigation on the activities of the Governors Forum in the era of Governor Yari. That's on one side. And on the Paris Club reform, there's been controversy, there's been back and forth, there's been news here and there. The issue is, in one breath, the parties agreed that there is a matter before the Federal High Court, which is on appeal presently at the Court of Appeal. And then there's allegation also, the Attorney General had insisted that there's a Supreme Court judgment. Nwoko had debunked that allegation that there is no Supreme Court judgment, and that if there is any Supreme Court judgment, he's ready to forgo his money. None of us had seen that Supreme Court judgment. I haven't seen it. And in that vein also, I also do not think that it is the duty of the Attorney General of the Federation, even though, according to the Attorney General of the Federation, the federal government guaranteed that payment and the state governor signed an indemnity letter or form for the federal government. Being a matter before the court, I do not think that it is the duty of the Attorney General to begin to implement a court decision. That's a court decision when the matter is on appeal, especially given the fact that the Attorney General is not a part in the matter. He just said that the consultant wrote a letter to him and wrote a letter to Mr. President, and Mr. President sought for his legal opinion on the matter. And to that extent, he went ahead to instruct that payment be made, despite the fact that the matter is currently pending in court. I also like the fact that Mr. President had instructed subsequently, after initially ordering payment, subsequently on the advice of the Federal Executive Council, instructed the Minister of the Finance to halt payment, because first and foremost, it is also not at this time of not at this time in the day where we are grappling for foreign earnings, that the federal government will be paying $418 million, especially also given the fact that there are controversies surrounding all of the allegations. And then lastly, I would say, if you remember, sometimes last year, I did accuse the Abia State government of deductions and percentage made on this same Paris Club reform. Because if you remember, after the reform had been made, the governors also created, the governors forum, headed by Yari, then also created a subhead and a contractor deduction from source the moment the payments were made. And then some state government also appointed consultants to help recover money that have been recovered. So there were a lot of subheads and then sleaze surrounding that reform. Nwoko had also said that EFCC, the matter is too technical for EFCC to handle. I do not think so. I also do not think that it is too technical for EFCC to handle. If the accusations of underhandling, especially given the fact that he had accused Yari also of collecting $100 million for and on behalf of other governors for the prosecution of an election. Is that not a criminal allegation that will warrant our security agencies and our financial crime experts to investigate? I think that should be. So I quite appreciate the concerns of all parties, but I think the sensitivity of the matter would ensure that this matter is handled with caution and allowed, and since parties have submitted the matter before jurisdiction of the court, allow the court to, exhaust, its powers in arbitrating or litigating over the matter.
But it seems from what is happening that both sides seem to be afraid of the courts? Because if this matter is still at the courts, why are we having this conversation and accusations?
That's the issue with Nigeria. You'll find out that we submit a matter to the jurisdiction of the court. Also, because there are windmill of justice here grind slowly. We say windmill of justice grind slowly but surely. But we also forget that justice delayed is justice denied. So you have some persons who claim to have worked, and like we say, a laborer is entitled to his wages. And payments were made in some trenches, and subsequently payments were stopped. And all these parties went to court. I know of individuals also who also had taken states to court, as regard the same reforms. So because there are delays, I think the parties now decided to use other means. But in using other means, since you have submitted to the jurisdiction of the court, other means should not be calling on Mr. President to override the court. Other means should be an alternative way of resolving the dispute, whereby both parties sit down and reconcile figures. The idea of now writing to Mr. President to come to their aid when a matter is in court. I also think that the Attorney General, that's why I think the accusation from the Governors Forum against the Attorney General that is self-serving, for me, I also want to agree with them that a matter that is in court, even if your legal opinion is sought on the matter, all you request for is to ask for a judgment that had been delivered, and then the processes filed in the current one that is in court, and not to now hastily give a judgment or in a matter that is in court, saying that government has, since there was an indemnity fund, bond signed by the governors to the federal government, since the governors had guaranteed payment, the federal government had guaranteed payment, an indemnity form was signed against that guarantee, then the federal government should release the funds. What you're trying to do is to foist a fait accompli on the court in the event that the court determine the matter one way or the other. I think the opinion and advice should have been to Mr. President that since the matter is in court, which has always been, the opinion of federal government in matters they don't want to get involved in. They tell you the matter is in court. Look at Nnamdi Kanu's case, for example. Even when the Hanese Ndigbo and Igbo elders went to appeal to the government to find a political solution to such matters, the president said, well, the matter is already in court. He didn't even seek the opinion of the Attorney General. But in this case, the matter is in court, judgment had been delivered in some cases, and everybody's aware that there's an appeal on that judgment. The governors are crying foul. The consultants are also crying foul. Now they've submitted their claim to the jurisdiction of the court. So there is no need even seeking, let's assume that the president is not even aware that the matter is in court. The moment the Attorney General became aware of that fact, the best thing to do would have been, well, guys, you have submitted to the jurisdiction of the court. And the best we can do is to ask the court to hasten decision and not to now begin to give a judgment or enforce an order that was not made by the court.
Liborous, it's significant that this matter is coming to a national reckoning. What baffles me is the paradox of the situation, that the person who is owed is supposed to be the one going to court. But the thing is upside down, that the person who actually paid, went into the case, who is supposed to be the
arbiter,
the debtor or arbiter, is the one going to court on behalf of those who are aggrieved.
You see, that's the absurdity of the Nigerian situation. If you listen to Nwoko, he talked about only his claim and said, I also think that press interview was not in good faith, even though there were some revelations made. Because if you, there are allegations that deductions were about $418 million, and you know that there are other consultants. And if you believe that as a lead consultant, you're working in tandem with other consultants, the best thing to have done in that circumstance would be to collate all of the claims of other consultants, but to come out and singularly speak about yours and made it look as if that is all there is, that what is owed is 68 million, and you do not know where the figures the governors are banding came from. Only for the governor to respond and break down all the claims as it is. You know, you put a hole in that claim. And then secondly, you have submitted a matter like I did acknowledge. You submitted a matter before the jurisdiction of the court. Why now write a letter to Mr. President for his intervention? I think the best thing would have been you withdraw the matter before the court, and then you now begin to seek for alternative way of resolving it. Also, the people, it is, for me, I'm still grappling to understand the rationale behind, you know, the interest of the Attorney General in the hasty payment of the sum owed, alleged sum owed, while you are aware that the matter is in court. And then, like you also observed, the people that are being owed are not the one that have approached the court. They should have been the one to approach the court to say, these are our claims. And there is a valid agreement entered into by parties, and you join the federal government that guaranteed the payment, join the state governors that are owing the money. But in this case, that is not the issue here. If there are claims that there's a Supreme Court judgment nobody has seen, that there is an order of mandamus. The Attorney General is also claiming that there's an order of mandamus against the federal government, directing the federal government to pay the money. Why there is also the allegations from the governor that there's a Supreme Court judgment. And also, parties are aware that there is a current judgment, there is a current matter pending at the Court of Appeal. All of this, they are conflicting orders. I also have expected that the Attorney General ought to have studied all of the orders, including, like I said earlier, including the pending matter. And then before you now take a decision, and not select the judgment to obey, and then, you know, decide not to obey the order.
All right, Mr. Oshoma, let me ask you perhaps two questions in one. Do we seriously need consultants to carry out this kind of transactions or to mediate for this kind of transaction? Do we really need them? Are they very essential? And then two, we find ourselves in a Japa area where people want to leave the country, but we're in a global era. How damaging is this kind of story or reports for the country as a nation?
Yeah, first and foremost, it depends on the job of the consultant. If the state government are not even aware that the deductions were made from their funds, and that the consultants were the ones that revealed those deductions, then the state will need consultants to sit down, financial consultant or financial analyst, to sit down with them and look at all of the illegal deductions. So just like you know, employing a financial analyst to look at your bank statement and point out, because on the face value, you will not understand the excess charges or illegal charges by the banks. But when a financial consultant who is trained in the act of looking at the fine lines, look through those documents, you'll be able to point out excess charges. That was what happened in the case of Guaranty Trust Bank and Innocent Motors. They employed a financial consultant to look at both books. So in that regard, if that's the case, then certainly you need a financial consultant. But if the case were that, illegal deductions had been identified by the Paris Club and the London Club, and then they decided to make refund, then in that circumstances, you don't need a financial consultant. You have commissioners, who are also, knowledgeable in this field. You have attorney generals who also will sit down and draw up an agreement with the banks making the refund. And so in those cases, you don't need a refund. But typical of Nigeria, whether you need consultants or you don't need consultants, we employ consultants to do everything. And that's why there is allegation against the former chairman of the Governors Forum, Aziz Yari, that even after the refund had been made, the Governors Forum appointed a consultant for and on behalf of the Governors Forum because they needed also to make deduction. In some states, even after refund had been identified, those state governments still appointed consultants. The case of Abia, for example, there were 2 consultants appointed. One claiming a percentage of 30%, another one claiming a percentage of 15%. So for the refund, if you take out 45%, what is left for the state, the poor state that is grappling for funds? And like you also identified, in this era of global financial crisis, and Nigerian's case is peculiar, one would have expected that the federal government, the state government, and the the consultants sit down like the federal government had done now, setting up a committee headed by senior advocates. I also think the Minister for Finance and the Minister for Budget and Planning and experts in financial figures should also be part of that meeting. It's not just to look at the agreement, but also to look at what was recovered and how percentage ought to be paid. Now, even your dollar that you have in your account, that you have deposited in your account, to withdraw it is a problem in Nigeria. And then government, if the Attorney General of the Federation is so much in a hurry, is in haste to dole out $418 million to some consultants, despite the fact that the matter is in court. For me, it's shameful.
From your point of view, Liborous, what do you think might be the Attorney General's interest in this matter?
Just like the Attorney General attempting to execute a court judgment in Lagos, despite not understanding the intricacies of the matter, I think Attorney General, a lot of people had called for the NBA, had made calls to the NBA to sanction the Attorney General. I think this is more of a personal interest than the interest of the federal government. Because if you say that there is an order of mandamus, directing the federal government to make deductions and pay to these agents, and the governors are also laying a counterclaim saying that no, there is such order has been appealed against, and there is another pending appeal. I think, and as an Attorney General, who is the chief law officer of the state, and also doubles as the legal advisor to the government, as an arbiter, what you should do is to look at the cases of both parties. If possible, call both parties to a round table to sit down and look at how the matters can be resolved amicably. Also, putting national interests at heart at this critical stage that we are in, considering the financial crisis we are in also. But to hastily make that judgment, the only deduction I can deductions I can draw from that, inference is the fact that the Attorney General, has personal interest in the matter. And we all know also consultancy. I'm not saying that it's probably been promised some consultancy, but if you make this happen, we know the way Nigerian businesses are run. If you make this happen, you have a certain percentage. So all of this will fund, personal interest to ensure that you use your power, for personal interest. It's against national interest.
All right, Liborous, we need to quickly go on a commercial break. When we return, we'll continue the conversation with you. Stay with us.